Understanding the law is the first step to fighting back. Here's what federal agencies just arrived in right now, and what it means for your family. More than 24,000 lawsuits. That is how many times detained immigrants have gone to federal court since January 2025 to say, "You cannot hold me without a legal reason." That number is larger than the total filed under the last 3 presidential administrations combined. And in the overwhelming majority of those cases, the courts are agreeing with the people who filed them. This is the story of habeas corpus, a legal protection older than the United States itself, and how it has become the single most important tool in immigration defense in 2026. Let's start with the basics, because this term matters. Habeas corpus is Latin for "you shall have the body." The concept dates back to the Magna Carta of 1215. It became a cornerstone of English common law, and the framers of the Constitution wrote it directly into Article 1, Section 9. The idea is simple and powerful. The government cannot hold you indefinitely without a lawful reason. If it tries, a federal judge can order your release. It is not a loophole. It is one of the most fundamental protections in the entire legal system. Before the second Trump administration took office, habeas corpus was almost never used in immigration cases. It was considered a last resort, something used after a criminal conviction, when every other legal option had been exhausted. Immigration attorneys across the country say they rarely, if ever, needed it. One Texas immigration law professor and former immigration judge said, "I don't recall a time that anything like this has ever happened." An Illinois attorney put it more directly, "We never had to do this before. We didn't even do habeas cases until this administration took over." That changed in July 2025, when ICE issued new guidance taking the legal position that nearly all immigrants without legal status must be held in mandatory detention, with no opportunity to request a bond hearing, while their immigration cases move through the system. That policy reversed decades of legal practice. For years, people who had been living in the country for years or decades with no criminal record and no indication they would flee had the right to go before an immigration judge and request release on bond while their cases were pending. That path was effectively closed. In response, attorneys had one remaining option: federal court. The numbers tell the story of what happened next. In El Paso, right here in the Western District of Texas, federal judges handled an average of 26 habeas corpus petitions per year between 2021 and 2024. In all of 2025, that number jumped to nearly 300. Then in January 2026 alone, filings came in at a pace that, if sustained, would produce more than 2,800 for the year. The record for an entire previous year was broken in a single month. Nationally, ProPublica's habeas tracker documented more than 18,000 petitions filed in the first 13 months of Trump's second term. By early March 2026, that number had climbed past 24,000. Immigrants were filing more than 200 of these cases every single day. California and Texas together account for about 40% of all new filings. Minnesota, which had just 12 such filings in all of 2024, jumped to more than 700 in 2 months, placing it third in the country. Who is filing these petitions? Many are represented by longtime immigration attorneys who pivoted their entire practices to meet the need, but a large portion are being filed by lawyers who had never handled a single immigration case before: corporate litigators, divorce attorneys, estate planners, criminal defense lawyers. They showed up, trained themselves, and started filing. In Minnesota, volunteer attorneys organized through the National Lawyers Guild and other networks. One attorney who typically handles divorce cases said she had to learn to file a habeas petition from scratch. She filed her first on January 27, 2026. Within weeks, she had represented more than 3 dozen detained immigrants. In Florida, an attorney who practices civil rights and intellectual property law filed about a dozen petitions for ICE detainees. In a large part, he said, these are people who are complying with the rules who are getting caught up in detention. The courts have been overwhelmed. The chief judge of the Western District of Texas acknowledged that courts in Austin, San Antonio, and El Paso were all seeing extraordinary volumes. U.S. attorneys have filed declarations telling judges their offices are being crushed. In Minnesota, the U.S. Attorney's Civil Division was operating at 50% capacity, with attorneys and paralegals working overtime continuously. Minnesota's Attorney General told a Senate committee his staff was drowning. And in one remarkable moment during a Minnesota court hearing, a government attorney who had been assigned more than 80 cases in a single month told the federal judge, "What do you want me to do? The system sucks. This job sucks." She was later removed from her posting. The government has responded to the flood of habeas petitions in another way as well. IC has been rapidly transferring detained people out of the jurisdiction where a petition was filed, sometimes across multiple state lines within hours of detention. Attorneys have told courts they cannot even locate their clients. Habeas petitions must be filed in the district where the person is detained. Transfers create jurisdictional problems that can delay or derail the entire case. In Minnesota, Chief Judge Patrick Schiltz, a George W. Bush appointee, released a list of cases where ICE had defied court orders to keep people within the state. He threatened officials with criminal contempt if violations continued. Here is what the courts are actually deciding, and why the legal argument matters. The government's position rests on Section 1225 of the Immigration and Nationality Act. The administration argues this provision requires mandatory detention for any immigrant who entered the country without authorization. Full stop, no exceptions, no bond hearings, for as long as their immigration case is pending. That can mean months. It can mean years. The administration calls judges who disagree rogue, and a Department of Justice spokesperson publicly stated that there would be no overwhelming caseload if those judges simply followed the law. The judges ruling against that position read the same statute very differently. They say Section 1225 applies to people arriving at ports of entry, not to people who crossed a border years or decades ago and have been living in the interior of the country ever since. Applying mandatory detention to someone who has been here for 30 years, they say, distorts the plain meaning of the law. Federal Judge Donovan Frank wrote that the government's interpretation contradicts the plain language of the statute. Federal Judge Damon Likety in Indiana wrote, "All parties must play by the rules. The same wisdom that requires immigrants and non-citizens to follow the law equally requires the government to follow the law." And Federal Judge Roy B. Dalton in Florida called the administration's legal position plainly incoherent and ordered 2 Justice Department attorneys to explain why they should not be sanctioned for bringing such a weak argument to court. The scorecard, as of late February 2026, a Politico analysis found that 386 federal judges had ruled against the Trump administration's mandatory detention policy. Only 33 had sided with the government. In one New York federal district, immigrants had won their habeas petitions in 350 out of 362 cases. These are judges appointed by presidents of both parties. Republican appointees and Democratic appointees are reaching the same conclusion at nearly the same rate. The law does not support what the government is doing. What does winning a petition actually mean for the person who filed it? In most cases, a federal judge orders the government to provide a bond hearing before an immigration judge. The hearing they had been denied. At that hearing, the immigration judge evaluates whether the person is a flight risk or a public safety concern. Many are released on bond. Some are not. The habeas petition opens the door. The bond hearing determines what is on the other side. One thing winning does not guarantee: staying in the same state. IC has continued transferring people even after judges order bond hearings, creating situations where attorneys are litigating in one jurisdiction while their clients are in another. One Illinois attorney filed a petition at 3 in the afternoon for a client detained at 9 that morning. By 3 p.m., that person was already in transit through Iowa, headed to Texas. Now let's talk about the people behind each of those petition numbers. Because the legal arguments are abstract, the lives are not. Heidi came from Ecuador when she was 11 years old. She had been granted the right to live and work in the United States under a federal program that protects victims of violence. On January 14, 2026, she was stopped by immigration agents on her way to community college in a Minneapolis suburb. The officer told her it didn't matter that she had documentation. He refused to look at her papers. She was flown to El Paso that same day. A Mexican man who has lived in the United States since 1995, 30 years, was arrested on his way to work. He had a valid work permit. He was sent to a detention facility in Texas. A federal judge ordered his release, writing that the government's interpretation of the statute disregards decades of prior practice and the plain meaning of the law. A Colombian woman pursuing an asylum claim was detained during a routine ICE check-in, the kind of scheduled appointment the government itself requires immigrants to attend. A Mexican mother and her two children, ages 8 and 14, were detained despite complying with every requirement in their immigration case since being permitted to enter the country in 2024. A high school student whose parents fled Venezuela was detained. The judge who ordered the student's release called the government's legal argument plainly incoherent. These are the people filing habeas petitions. People with U.S. citizen children. People who have been paying taxes, attending school, and following the rules for years. People who showed up to their required ICE check-ins. People who entered without authorization a decade or more ago and built entire lives here. The administration argues the law requires their detention regardless of any of that history. The courts, in the vast majority of cases, have said otherwise. There is another reality that does not appear in the official statistics. Habeas corpus petitions with private counsel cost between $12,000 and $18,000. Most detained immigrants cannot afford that. Attorneys who have won case after case say they know there are thousands of people in detention right now who would very likely prevail, but who are signing removal orders instead because they cannot access the courts. One Utah attorney said, "There are hundreds and hundreds of people, thousands, who are incarcerated, who have no criminal history, who would absolutely win a habeas petition. But because they cannot find counsel, they give up, they sign a removal order and leave. Access to the courthouse is not the same as access to justice, when the cost of the key is $15,000. There are two legal developments that directly affect people detained in Texas, and both matter to understand. The first is a ruling from the Fifth Circuit Court of Appeals, the federal appeals court that covers Texas, Louisiana, and Mississippi. In late February 2026, a divided three-judge panel on that court sided with the administration, holding that bond hearings are available only to immigrants who entered the country through lawful channels. For the majority of people detained in this region, people who crossed without authorization, that ruling means mandatory detention with no path to a bond hearing through the regular immigration court process. A former immigration judge called the ruling devastating. As a result, the federal district courts and habeas corpus petitions have become the primary avenue remaining for challenging detention across the Fifth Circuit. What happens in El Paso's federal courthouse is carrying enormous weight right now. The second development comes from the Supreme Court. Last April, the court ruled that challenges to unlawful immigration detention must be brought as individual habeas corpus petitions, not as broad class action lawsuits attacking the government's policies across the board. That ruling pushed even more cases into the habeas pipeline, directly contributing to the surge. Appeals in habeas cases are now pending in 9 of the 12 regional federal circuit courts. Those courts are not all reaching the same conclusions. When federal circuits disagree on how to interpret a federal statute, the Supreme Court typically steps in to resolve the conflict. Legal observers say it is approaching inevitability that the court will take up the central question: does the law require mandatory detention of undocumented immigrants who entered without authorization and have lived in the interior of the country for years? That case has not yet arrived at the Supreme Court, but the circuit conflict is building, and the pipeline is full. There is one more thing worth knowing. White House officials have publicly discussed the possibility of suspending habeas corpus entirely for immigration cases, pointing to constitutional language that allows suspension in cases of rebellion or invasion. That power belongs to Congress, not the president, and it has been used only 4 times in American history, all during wartime. The most recent was in Hawaii in 1941, following the attack on Pearl Harbor. Legal scholars across the political spectrum say the current situation does not come close to meeting that threshold. No formal suspension attempt has been made. Federal courts are open, and they are hearing these petitions. Here's what you need to know right now. Practically, if you or someone in your family has been detained or is at risk, time is the most important factor in a habeas corpus case. The moment someone is detained, the clock starts. IC has been responding to the wave of filings by rapidly transferring people out of the jurisdiction where a petition would be filed, sometimes crossing multiple state lines within hours. File as fast as possible. The faster a petition is filed, the harder it becomes for ICE to execute a transfer that could derail the case. Document everything, starting today. If someone in your household is ever detained, write down the date, the time, and the exact location. Record the names or badge numbers of any officers involved and exactly what was said. If an officer refuses to look at documentation showing legal status, write that down, the date, the location, and what the officer said. If you receive paperwork, keep it. If you are refused paperwork you should have received, document that too. This information can become part of a habeas petition. Legal help is available, including for families who cannot afford private counsel. Volunteer attorney networks have organized across the country specifically to handle habeas petitions for detained immigrants. The National Lawyers Guild, local legal aid societies, and immigration nonprofits can connect families with attorneys who are trained in actively taking cases. Many of those attorneys did not practice immigration law a year ago. They learned because the need was there. Some firms are funding petitions directly for clients who cannot pay. If you are looking for help, ask specifically about habeas corpus and whether pro bono representation is available in your district. If someone you know is in detention and has been denied a bond hearing, that denial can be challenged in federal district court. Courts in this district are hearing these cases. The majority of federal judges who have ruled on this issue have sided with detained immigrants. That legal landscape could shift as cases move through the circuit courts toward the Supreme Court. The access that exists right now, the open courthouse door, is the one to use. Stay informed and know your rights. Record today, protect tomorrow.